order is 760% greater than normal usage. And I talked to Pittsfield Township. It's over $1,300. And my normal usage rate is about $183 per quarter. So I talked to Pittsfield Township, and they said that there may be an issue with the water running. And I had requested that me or my contractor take a look, and I was denied access.
Ms. Lyman, what's your position on it?
The water that was running, the outside hose was on the side of the house, and I had turned it off. It's been off since the 2nd, and they notified me.
How long was it on?
It's been on for 20 days. It's because of the nozzle.
Okay. Well, if it was running for 20 days, then.
Yeah, but I handled that problem.
You what?
I turned it off, so it's not running anymore. It was the outside hose.
Okay. There's no flooding in the premises, is that correct?
Correct, no flooding.
Okay. That was the thrust of your motion.
Yes, I was concerned about the structure.
And she's indicating there's no flooding.
Okay. If she could talk to me, call me on the phone, and so that I can rest assured that it's okay.
You have been in here time and time again. I cannot force you guys necessarily unless you're both here to talk to each other. What you guys do outside of here, I can't control everything. Okay?
Okay, sir.
So you haven't given the reason for that, and it makes some sense. The emergency motion is denied. And that's it.
Okay.
All right. Thank you. Thank you, Ms. Lyman.
Thank you.
Yeah, writing in there.
I know.
Okay, are we ready on anything? Sure. Call me to death. Court does call the case of the people versus Ryan Patterson.
Morning, Your Honor. Alex Warren Green on behalf of Mr. Patterson. Mr. Patterson, could you state your name for the court, please?
Ryan Lee Patterson. All right. What are we doing?
Your Honor, Mr. Patterson is signing a preliminary exam waiver. He does wish to waive his right to the preliminary examination. We are working towards a non-prison resolution of this case. That would be based on his waiver today, his continued compliance on bond, and his ability to abstain from criminal activity moving forward.
That's correct.
Sir, you're waiving your right to have a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause if the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on the single count. Mr. Warren.
Your Honor, we acknowledge receipt of the information, waive its reading, and stand mute.
Defendant every way for reading standing mute. The court will enter a not guilty plea pre-trial and will be set.
30th at 1:30 with Judge Slay.
October 30th, 2025, 1:30 before Judge Slay.
Thank you, Your Honor.
Bond will continue. Oh, I do have to do that, don't I? Mr. Warren Green.
Yes, Your Honor.
Do you know the waiver? Because I have to do it. Miss Zenda.
Oh,
People have granted full waiver is had to handle between this honorable court and office of the public defender while people don't believe such power exists. People make this waiver and have waited for all that.
and Your Honor,
You can spit it out. Go ahead, Warren.
for our part, we would also, we acknowledge that we do not believe a waiver or a conflict exists. To the extent that a conflict does exist, we would waive it. If a conflict were to arise, we would waive that moving forward.
Okay, you just know. The corporate part also does not believe there's a conflict either in Michigan court rules. Other cases decided they're under to the extent a conflict does exist, given the waivers the court will consent to hear. Thank you.
Thank you, John.
Court does call the case. People State of Michigan versus Seth Anderson.
Now this is
Brian Bowling on behalf of Mr. Anderson, Your Honor, who's approaching. State your name for the record, Seth.
There isn't one in there, Mr. Ward. You guys are gonna have to prepare one.
also the new.
Just state your name for the record again.
Seth Anderson.
Judge, he's prepared to waive his right to examine.
All right. Is that correct, sir?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it.
Correct.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on count one with two following.
Judge, for purposes of arraignment, will acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant having waived formal reading, standing mute to both counts. Court will enter a not guilty plea. Pretrial in this matter will be set November 3rd, 2025, 1:30, Judge Hoen.
Thank you, Your Honor.
Bond will continue.
Sure. Don't rather than me. Your Honor, me.
Douglas, this one does have the information that you need. Okay, that was fun. Johnson, how are you today?
Good idea.
Good as I can be. I don't know what that means. Court does call the case of the people versus Rashad.
And this is people you're on.
Good morning, Your Honor.
Morning.
Hi, Summer CP number 68565 on behalf of defendant.
Rashad Ahmed.
You're on today's day, you have to have a preliminary examination. At this time, people are on count one to asset, count two be remanded down to district court.
Count one is dismissed, people being unable to proceed. I'll continue the defendant's plea of not guilty as to count two. A pretrial will be set in this matter
October 27th at 10 a.m. Judge Wild.
October 27, 2025. What time?
10 a.m.
10 a.m. before Judge Washington.
Thank you, Your Honor.
Thank you, Bond. We'll continue.
Thank you.
Court calls the case people versus Candace Fair.
Yeah.
that I've seen council.
Miss Ackerley is gracious with her presence, or is she?
Your Honor, I will go and see if she is here. I did it for her earlier.
Did you?
I did.
Tell her I'm angry. That will not make her go any faster. Oh. No. They already vote.
No, I have not anything published. From those published to the expertise of whole person.
The three of us?
Prosecutors.
Oh. So. But why are you back if you don't have her?
Your Honor, I was
Why
not.
are you back? If you don't, you told me you were going to go get her because you saw her. I told you to go out, gave you specific instructions. You came back in here empty-handed. And now you want to talk to me.
I was thorough in my search. I did not find her.
You were thorough in your search. You didn't find her.
I would
So
respectfully,
action really has just disappeared.
and I would respectfully ask if the court can pass this matter. I will.
I just
find
called
her.
it like, well, 10 minutes ago because you were gone for like 2.
For the record, I also see this fair, so I'm not sure if they're leaving talk.
I could issue a bench warrant for both. Right? Is that what you want me to do, Miss Ann? No? She's so nice. What?
Kennedy was like,
I know Kennedy does that. Good job.
Thank you, Your Honor. Appreciate it.
Court calls case people versus Mark Cochin.
Yeah.
You want to know why?
Good morning, Your Honor. I am Shannon Smith on behalf of Mark Cochin, who stands to my right. Can you please state your name for the court?
Mark Cochin.
In fact, a preliminary examination of this type of people are unable to proceed.
And Your Honor, based on that, the defense would be asking the court to dismiss this matter.
People being unable to proceed. This case is dismissed. That's without prejudice. Thank you.
Thank you.
Thank you, Your Honor.
Oh,
I'm not saying anymore before you yell it. Or have.
I'm gonna wait for her to sit down and then call her king. Psych, no. Why are you, what are you handing me?
What
Just do no more. Oh. To see. Janaza, everything was going fine. Everybody was getting along just fine. And then came you.
My case. What was the name?
Do you have a client? Or are we gonna, is this an excuse? I think that's a yes or no. It's really simple, Janaza.
Good morning, Your Honor. I spoke with Ms. Fair this morning.
So this is a no.
So now, but what? So she went to 14.
I'm not calling the case.
Okay.
Sit down. Is she gonna be here
Yes, yeah. She was 9
today?
away 5 minutes ago.
So what are we doing?
Is the county due today? I don't see it's one in the referral you do something. You just hold on to your name. It's the comparison. But they can
So no. We didn't refer.
correct.
What's that? What's the second?
We referred it. No order was presented to you for signature. Unless I missed it.
But why do I have to do that? Is it separate preemptive?
It is conference previously, did a conference, which is what.
But nobody.
But I do not think that there is no fit.
Suppressed your guns.
Miss Tanner.
And bowling.
Mm-hmm.
This could be a problem. Welcome back. All right. Well, Ms. Tanner, Mr. Bowling, can you approach, please? Mr. Bernstein and Mr. Johnson's clients are.
Yes. Thank you.
Know what we're doing on that.
I will not receive any of them.
Court does call the case of the people versus Joshua Pelfrey.
Good morning, Your Honor. Edward Driggis on behalf of Joshua Pelfrey, who is approaching. Joshua Pelfrey? All right. What are we doing?
This is the tenants of preliminary examination. If you're unable to proceed.
Right now, I would move to dismiss.
People being unable to proceed. Case is dismissed on defendant's motion. Thank you.
Thank you, Your Honor.
Might as well. Mr. Johnson, Mr. Bernstein, Mr. Cook, can you approach this? It does call the case of the people versus Delorian and Duro.
Good morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Duro coming up to the podium. DeLorean, can you please state your name for the court?
Delorian Duro. Thank you.
This is the date and time set examination on this matter. As we discussed at the event, people are requesting an adjournment. I believe that there's no objection. Defense counsel, for the record, we are able to proceed today.
No objection, Your Honor.
All right. This case will be adjourned. And it will be adjourned to September 30th, 2025, 12 noon before me.
Got it. Thank you, Your Honor.
Thank you. Where is he? So Bernstein, if you see Mr. Johnson out in the hallway, can you tell him his client's coming out?
Yeah.
Where is he?
She's not a Susan, Your Honor.
Is he?
You respectfully request.
Okay, well, yeah, tell him.
So I'm just trying to get a sense of what Good morning, Your Honor.
Good morning, Miss Bowdhead.
Pretty good.
It's the only time it's going to happen today.
All right. Well, I don't have anything in front of you today, so that'll work.
It's because I was concentrating.
Yes. Yes, I understand. Me too. Yes, we need to restart this.
So,
Round rounds and one side.
well, but they're a customer. Damn. Court calls the case of the people versus Rashad. All four cases.
I'm about to bring on behalf of Mr. Scott. Good morning, Your Honor.
Good morning. Your name?
Oh, Barazante Scott. Just Mr. Judge Simpson, sir.
Did you get new glasses?
Yeah, I did. I can't see.
Can you see now?
Yeah, I can see. Now.
Okay, that's going to be okay. All right, what are we doing?
Today, people are not able to on case 25F20276. We asked the agencies until he without credits. I believe that Mr. Scott is waiting on.
That's correct, Your Honor. I'm having him sign the examination waiver forms for the other three matters on the docket.
All right. And with reference to 3276, people being moving to dismiss, Mr. Brown.
Move to dismiss.
In that case is dismissed on defendant's motion. And then in the other matters, he wait.
Yes, Your Honor.
All right. Mr. Scott, you're waiving your right to a preliminary examination in these other three matters?
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on the three counts contained in the case ending in 1263. The two counts in case 1265 and the single count in the other matter ending in 0532.
Ron Brown appearing on behalf of Mr. Scott, waive reading of the charges, stand mute and request adjourn pre-trials in front of Judge Slade.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all counts. Pre-trial in these matters will be set
Judge Slay.
September 25th, 2025, 1:30 before Judge Slay.
Thank you, Your Honor.
Thank you. Found it. Raj, take care of yourself.
You too, sir. Thank you. All y'all take care.
Doesn't seem to be one.
Coach.
Hang on one moment. What was the pre-trial then?
It was September
25th. You could affirm. Yes. I don't want to make that burning. Yeah. It's like, where is Towson? Court calls case the people versus Cody Wine.
Morning, Your Honor. People.
Oh,
Good morning.
good morning, Miss Tony. It's like, what day is this? She's here.
I know.
I know. I see you and Miss Payton.
It's like a time warp.
Like it's a Monday or something.
I don't think I put in my parents. Lauren Parenting on behalf of Mr. Wine. State your name for the record, please.
Cody Michael Wines.
Your Honor, this is being time set for preliminary examination. At this time, the people are unable to proceed.
Move to dismiss.
People being unable to proceed. This case is just, that's on defendant's motion. Thank you, sir. What? What? I can't hear you.
That's all I have ready for you at the moment.
Wow, so loud.
Yes. Fair, it's here, but I don't have it. It's not getting moved.
What? Where's that ruling?
It was Alex's turn to walk.
He messed it up the last time. Who was
Oh, I don't know where she is now. You're at home. Sorry. But I'm here to tell you, I was the one who found her last time. And
Oh, you did?
Yeah.
See, I knew, and you should have taken credit for it.
Very arrogant.
Where?
I'll try to find her again. Work my magic.
Thank you, Miss Payne.
Whoa.
Fuck. See, that's how it's done, Warren Green. Warren Green goes out, disappears, 5-10 minutes, comes back, nothing. Kate just thinks about it, and I can really appear. She's probably a hologram, but that's okay. Is this it? Court does call the case, people versus Candace Fair.
And then on behalf of people.
And good morning, Your Honor. Assistant Public Defender Tanazi Kiriakin-Ruli on behalf of Ms. Candace Fair, who's approaching. Ms. Fair, state your name for the record, please.
Hello, Candace Fair.
Thank you.
Your please state time set preliminary examination. At this time, you are unable to proceed as to count one, and as that count two be remanded to district court.
So the court will, people being unable to proceed, you're moving to dismiss count one.
Yes, Your Honor.
Count one is dismissed. I'll continue a not guilty plea as to count two. This will be set for pretrial
October 16th at 10 a.m. with Judge Walsh.
October 16th, 2025, 10 a.m. before Judge Washington.
Judge, do you know if that's by Zoom or in person?
How am I supposed,
Really?
how am I supposed to know that, Miss?
We were almost out of here.
I'm sorry.
How,
We
you
were.
want us to find out?
No, Your Honor, we will
You
call.
want me to find out? Find out.
My boss is already. I have to go back to work.
We will call and find out all the information we need for the hearing, Judge. Thank you.
Do you have another case?
I've got 3 in front of you today, Your Honor.
Oh, joy. Thank you, Miss Fair.
Thank you.
Do you know if that? I have no idea. Court does call the case of the people versus Vincent Lambert.
Brian Bowling on behalf of Mr. Lambert, Your Honor. Please approach.
Vincent Lambert. This is the date and time of the preliminary examination. This time people are on you.
I would move to dismiss then, Your Honor.
People being unable to proceed, this case is dismissed on the motion of the defendant. That's without prejudice.
Thank you.
Thank you.
See you.
He's back.
No, they're breaking. I'm in soccer moves out of way. Were you? I talking to there. I don't.
No.
Yeah. This is a comp review. Let's call the case of the people versus Montel Gatlin.
And about the conviction of the I can rule, Your Honor, on behalf of Mr. Gatlin, who's approaching.
Could have done this before he came out. Okay, no, I didn't mind waiting.
Mr. Gatlin, state your name for the record, please.
Montel Gatlin.
Thank you, sir.
So, Your Honor, we are here today for a competency review. I have spoken with the doctor at the Forensic Center. He states that the report will be done by the end of this week.
That it will be done by the end of this week.
That's what he said, yes.
Okay. Then what I will do is I'll adjourn the comp hearing, no report, to September 30th, 2025 at 9 a.m.
Okay. Your Honor.
I'm putting it with my PCC docket at 9.
What day?
Pardon?
I didn't hear the date, Your Honor. I apologize.
What?
I didn't hear the date that you gave us.
Didn't I? Was I loud? Or was she not listening? Which do you think it is?
I wasn't paying attention.
Mr. Johnson heard the date. Everybody heard the date but you.
I apologize.
Why is that?
I was multitasking, but I wasn't doing very well.
September 30th.
Thank you, Judge.
2025, 9.
Your Honor, my client would like for me to address bond, please.
Go ahead.
Judge, Mr. Gatlin reports that he has an address where he will be living with his aunt. He states that he has a job waiting for him with Root plumbing company, where he will be able to make very good money. He states that he previously requested that my office be removed from his case. He's trying to see if he can raise money to pay a private attorney to handle his matter for him. I think in the meantime, I will reach out to the Office of Assigned Counsel and see if we can get him someone temporarily. However, he wants the court to understand that he is okay with a tether of any sort that the court deems necessary to allow him at least to get out and start working. We know that competency is at issue, but I think that a tether would be able to cover any issues that the court or the people may have in regards to complaining witnesses and safety as well as flight risks, Judge.
Respond.
Your Honor, we asked to not be a change in bond. Given what the allegations are here, we don't think that a tether by itself would be sufficient. With the Hoen case, we have Mr. Gatlin allegedly fleeing from multiple officers, and if officers trying to pull one over isn't sufficient to make them stop, then I don't know why a tether is something that would make somebody stay at home. Here we have the allegation that but as a high speed, he crashed his car and then fled on foot, and that he had 2 children in the car. Left. We saw around him money near the car. It's to do with the effect of high flight risk and danger, so we're having to punish.
The court's going to deny the request to change the defendant's bond. In this case, the court would find, given those circumstances, at least as alleged, that the defendant would pose a risk of flight, and also that he poses a danger to the community by leaving the children at the location that he did. So his bond will continue.
Thank you, Your Honor. Thank you, Judge.
Thank you. Court does call the case of the People's State of Michigan versus Ladonta.
Your Honor, we have people.
Better now, hey, I have Mr. Skinner, who stands to my right. Please say your name, director, sir.
Thank you.
As of the date and time set before our examination, people are able to proceed.
All right. Ready to go? Let's go.
Just as a preliminary matter, there is an exhibit, people proposed exhibit 1. I've discussed with the defense counsel some cell phone footage from the incident. I believe that that's going to be stipulated to being admitted.
That is correct, Your Honor.
Exhibit 1.
The first examination, Your Honor, yes.
Okay, very good. You may proceed.
Thank you. The people called Brent Bucknam.
Please come forward. Be sworn.
Take a seat, raise your right hand. You solemnly swear to affirm the testimony question if you do. I want you to know that state and spell your first and last name to the record, please.
Brent Bucknam. BTBCKNAM.
You may inquire.
Thank you. Good morning, Mr. Bucknam. How are you? Mr. Bucknam, where were you on April 10th of this year in the afternoon hours?
In downtown Ypsilanti.
What were you doing in downtown Ypsilanti?
Transporting packages from my place of employment to post.
And where is your place of employment?
Yes.
And you said in Ypsilanti, is that here in Washtenaw County? All right. While you were transporting these packages, what route were you taking?
I was going south, crossing Michigan Avenue, with one.
What did anything happen out of the ordinary while you were transporting those packages?
I passed the defendant on the right, leaving about 3 to 4 feet of space between us. And when you say you passed this individual on the right, were you on foot, in your car, on a bike? How are you transporting? What about the other individual? And do you see that individual in the courtroom today? Can you please point to him and identify him by an article of clothing that he's wearing? Your Honor, the record may reflect that this witness has identified the defendant.
I've had objection records, so reflect.
When you passed by the defendant, what were you doing specifically?
I was transporting packages. One hand was pulling a bag of packages, and the other hand was pulling a larger package.
And at the time that you passed the defendant, what was he doing?
He was standing.
Okay. And how much space was between the two of you when you passed by him?
3 feet.
When you passed by the defendant, did he say anything to you? What did he say?
He said, "You should say, 'Excuse me, bitch.'"
What happened after that?
I ignored it.
Were you able to continue walking? How far were you able to continue walking?
10 feet.
What happened after you got to that 10 feet?
He began making statements in an attempt to intimidate me.
And when you say he, are you still referring to the defendant or some other individual? Okay. What sort of statements was he making?
He was saying, "I will put you in a body bag. I run this street. I will shoot you. I will stab you."
How did that make you feel? Did the defendant ever get physical with you? When did that happen?
Later, going south of Washington.
So about 20 feet then from where you initially passed the defendant? What did he do that made physical contact with you?
He punched me in the face.
How many times?
Probably about 12.
20 times? And when he first punched you in the face, did you see it coming? Was it from behind? How did that happen? All right. What did you do when you saw that punch coming?
Tried to push him away.
Were you successful in pushing him away?
He got on top of me and began to attack me some more.
When you say he got on top of you, are you on the ground now or are you still standing? Okay. How long was he on top of you?
10 seconds.
And while the defendant was on top of you, what was he doing?
He was punching me in the face.
What got the defendant to get off of your body?
I managed to stand up.
So you managed to get yourself up and push him out of the way? Okay. After you were able to stand up, what happened next?
He said, "I will shoot you. I will stab you. I'll take your packages." And he also picked the larger package that's on the dolly.
Okay. At that time, did he have anything in his hands? Did he ever have anything in his hands? What did he have in his hands?
He had a large, flat, mechanic style screwdriver, about 10 inches in length.
When did when did the defendant get that screwdriver?
As he was running away towards the Bryan property next to the vehicles.
So when did he run away?
After punching me in, after I managed to get up.
Okay, so he gets you on the ground, you get him to get off of you, and then he runs away. Is that what you're saying?
I pushed the wall to defend myself, and it never done so.
Okay. What were you doing as the defendant was running away?
I got my phone out.
Why did you get your phone out?
To have his attention.
Had you met the defendant prior to that day? Okay. Were you able to record the defendant? What happened while you were recording the defendant?
He said, "I'll stab." And he continued to run away.
At any point, did he raise the screwdriver or threaten you with that screwdriver? When did that?
Yes. Was running away probably near cooler for his own mother.
And what did he do exactly with the screwdriver that threatened you?
His hand while verbalizing on stat.
Do you know how far away the defendant was when he made that statement?
Oh.
When he raised screwdriver and threatened you with it, what was going through your head?
I was concerned about the stat, so I did not pursue the journal.
So you believed that he would stab you?
Yes.
Okay. And after the defendant makes this statement, what happened next?
He continues to run away onto Brown Hope's property.
Did you follow the defendant?
Yes.
Okay. I'm going to try and hook up, and if I may publish or going to move to admit what's been marked as people's first exhibit 1. I believe it's been admitted by stipulation at this point.
Exhibit 1, if I haven't said so, second.
Thank you. May I publish?
Sure.
And just for the record, I put up People's Exhibit 1 just before I start playing this. Sir, do you recognize this still frame? And is this the video that you took depicting what happened that day?
Yes.
All right. I'm going to play People's Exhibit 1. It's a video about 19 seconds long. There should be audio to go along with it, hold please.
You'll be hated, hateful, murder, stabbing, stabbing.
We can take from you. Perfect, thank you. No further questions, thank you.
Cross-examination.
Your Honor.
Well, Mr. Bucknam, my name is Natalie Pate. I'm an attorney for Mr. Skinner. I just have some questions to ask you to follow up on your testimony that you given to the court today, if that's okay. If at any time you either don't hear my questions or frankly they don't make sense or you just need me to repeat it for whatever reason, let me know and I'm more than happy to do so. So at the time of this incident in April, you were an employee of the Rocket? And that's like a gift toy store, right? And do you still currently work there? And how long have you worked there?
14.
10 years. And you testified that you were on your way to the post office at this time, correct? And I believe you testified that it was like a dolly you had your packages on, right? And is this dolly, is this something you like pull, for lack of a better term, with a handle behind you? And how large would you say that cart is?
And when extended, it's about 4 feet high.
Okay, thank you. And so when you were walking with your packages on your way to the post office, you bumped into Mr. Skinner with your cart, correct? At one point, however, he did turn around and tell you something to the effect of, you could have said, excuse me, correct?
Yes.
And some sort of verbal altercation ensued. And this was right outside of the beer cooler in Ypsilanti, correct?
Inside the tap.
Inside the tap room?
So started inside the Broadwell property and continued outside the tap.
So we obviously all just saw the video that we watched, and you took this on your cell phone, correct? And you'd agree with me that Mr. Skinner is walking away from you in that video, correct?
Video, yes.
And you'd also agree with me that the video depicts you continuing to follow him while filming, correct?
Correct.
And this video does not depict Mr. Skinner following you? And you would also agree with me that Mr. Skinner, we did see in the video that he did hold up a screwdriver, correct? You'd agree with me that at no point did he walk towards you while having that screwdriver in his hand, correct?
He turned around, but did not walk towards me.
Thank you. So just a couple of other questions, Mr. Bucknam. I may have missed it when you were testifying about how the screwdriver came into play, and maybe honestly, I'm just a little bit confused. So how I understand it, there was a verbal altercation and then some sort of tussle. Where did the screwdriver come from?
He must have had it on his person.
Did you see it at any time before this altercation? And during the verbal altercation in this mutual tussle, did he at any point take out the screwdriver if he had it on? So you testified today that Mr. Skinner threatened you or threatened to shoot you. Did you at all any time see him with a gun? When he made these verbal threats, did he present any sort of weapon? Did he present any sort of object at all when he made these threats? Did he even have anything in his hands? Thank you, Your Honor. No further questions for this witness.
Any regret?
No, Your Honor. Thank you.
All right, thank you. Sir, you may step down.
Apparently, people have no further witnesses and we rest at this time.
Any witnesses for the defense?
No, Your Honor.
Do you have a motion?
Your Honor, people will move for bind over on count of 1 for assault, count 2 to follow. I believe the evidence the court heard was that the victim was walking down the street just doing his job. When he passed by the defendant became agitated at him and then proceeded to punch him. I believe the testimony was about 20 times, getting the victim on the ground. While the defendant was fleeing from that assault, the victim recorded him, and the defendant, as the court saw, raised a screwdriver at him and said, "I'm going to stab you." He raised it in a threatening manner. Believe that the evidence shows by probable cause standard that an assault occurred where the victim did state that he was afraid.
Well, why would that be an assault on this individual? Why? I'm talking specifically about felonious assault.
Because the screwdriver, I believe, is a deadly weapon that satisfies that element. That's supposed to why it's an assault. That's because he raised it, threatens him. I believe the victim testified that he was afraid that he was going to get stabbed, and he said as much, and that's why he stopped following him. So I believe that shows that he had that apprehension of an immediate battery.
I get that, but at the same time, the physical altercation which occurred on the ground with the 20 punches to the face, that has transpired. As I understand the witness, they then testified that that attack is over.
Correct.
The defendant, according to the testimony of the witness, then is leaving the scene.
Yes.
The witness then follows that.
Correct.
And is in essence saying, "Leave me alone."
The defendant is making a statement. Yes, I want to.
Yeah. And says what he's going to then do.
Yes.
So at that point, why is that an assault? Why he is retreating from, assuming given the testimony occurred, a bad act has occurred. He is then leaving from that bad act.
Yes.
He's then followed by Mr. Buckner.
Yes.
And then turns and that's when he says,
Yes, and people's argument is when he makes that turn,
go ahead.
when he makes that turn, makes that statement, I believe the video showed him raise his arm and lift the screwdriver in a threatening manner. And given that motion and the victim's statement that he stopped following because.
But why would that be an assault by him?
Because he's making the victim fear an immediate battery.
But only because Mr. Putnam is following.
Yeah.
That's the only reason. The only reason that that portion of the altercation occurs is because Mr. Putnam goes after him.
Yes, and I believe the victim testified the reason he was recording was in order to get the defendant's identity due to that assault. He was trying to make sure that this could be responded to. I don't believe that following a defendant gives that defendant the right to then threaten that individual with a screwdriver, especially in an area that's open to the public and there's no reasonable expectation of privacy.
I don't know where the privacy issue comes in, but okay. All right. Response.
Your Honor, I would object to the bind over on account of assault with a dangerous weapon. I would argue, Your Honor, that there was no assault with a dangerous weapon or the screwdriver. The complaining witness did testify that Mr. Skinner at no time stepped towards him while the screwdriver was in his hand. Obviously, we all saw the video and that Mr. Skinner did raise his hand up while holding a screwdriver while he was being followed. He made no movement and did not put the complaining witness in a position of a reasonable fear of a battery. Given the nature of the weapon also being a screwdriver, to be candid, it's not a gun. Without any movement towards the complainant, my client would not have been able to assault him with a dangerous weapon. That being said, Your Honor, I would object to the bind over, and I do believe even by a problem.
Well, he wouldn't have to necessarily make a movement. He would just have to have the ability to come into contact. Which if he had run in the direction that the camera was pointing, he'd done that.
Absolutely, Your Honor. If he had run that way or chose to flail that object in his direction. But of course, that's not the situation we have here. Mr. Skinner, there was some sort of fight. I won't dig into that. Mr. Skinner was walking away from it. He had an object in his hand. He was being followed. He turned around and told the complainant whatever he said. And I would argue that the people did not meet their burden even by a probable cause standard and object to the bind over on this charge, Your Honor.
Anything additional from the people?
No, Your Honor.
In this case, the court listening to the testimony of Mr. Button, and I think it's important to place the court's distinction as to what transpired based upon the testimony of Mr. Button. There was first this assault, which occurs where he's indicating that he's punched 20 times. At some point, he's on the ground, but he then gets himself up and the defendant is up at that point in time. The defendant, begins, and I'll call it a retreat. He basically begins to retreat. It is then Mr. Putnam that is continuing. He may have a justification for what he's doing, but he's continuing the potential altercation as he's following it. And it is at that point, and remember Mr. Buckman's testimony is that he doesn't see the screwdriver, he's only presuming that it's on his person. Don't know that, but he's presuming it's on his person at the time of the initial assault. But the defendant is leaving. He's following for the purposes of identification. The threat, there is no longer a threat to Mr. Buckman, other than the one that he is then creating. The defendant turns around, says what he's going to say, raises the weapon. Because of that time frame, the defendant, while he may not have acted right, at the moment that is happening, he is not acting unlawfully in what he's doing and would be entitled to be there and potentially defend himself from what may be an oncoming assault of of Mr. Buckman. Maybe, I don't know. So for those reasons, and the court looking at these as two very distinct acts, as I listened to the testimony of Mr. Buckman, the court is going to decline to bind over the defendant on the assault with the dangerous weapon, finding that at the moment that weapon is exposed, it's not an assault with a dangerous weapon. It could be a number of different things, but it's not an assault with a dangerous weapon. And we'll remand it on the aggravated assault to 14A2.
Thank you.
I will set pretrial on count 2.
September 24th.
September 24th, 2025, 10 a.m.
Yeah.
10 a.m. before Judge Barth. Found with its conditions will continue. Please. Wow. Court does call the cases of the people versus Tyler Maddy.
Morning, Your Honor. Kenneth Overwater, Assistant Public Defender, on behalf of Mr. Maddy, who's approaching. Mr. Maddy, would you state your name for the record, please?
All right.
And this date and time set for preliminary examinations on both matters. We have reached a resolution subject to the court's approval.
I have in the case ending in 1463 a plea form that indicates that the defendant would be pleading to retail fraud in the second degree, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. In the other matter, 15th District Court case, it's also the defendant would be pleading to an added count 2, retail fraud second degree, count 1 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Your Honor.
Yes, Your Honor.
May I have him sworn?
Right. Do you solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth? Love you, God. State your name.
Tyler Maddy.
All right. Sir, it is this court's understanding that you're going to plead to 2 charges of retail fraud in the second degree. Is that correct?
Sir.
Those are misdemeanors carrying a maximum penalty of up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Sir.
All right. You also understand, sir, in the 15th District Court matter, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes.
All right. Understanding all of that, you still wish to plead guilty to these charges?
It would be too much more if he would sentence me. It would be doing too much. I understand.
All right. Do you still wish to plead guilty?
Yes, sir.
To the charge of retail fraud second degree occurring in Pittsfield Township contained in case ending in 1463, how do you plead?
Guilty.
To that same charge as contained in the case ending in 5714 occurring in the city of Ann Arbor, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct?
I have.
Any questions regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
On probation.
Were you on probation at the time of these offenses?
I was not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you in any?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty?
Yes, sir.
Starting in case 1463, on the date of May 8, 2024, at the location of 3900 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, what did you do at the Lowe's store that makes you think that you're guilty?
I stole a couple power tools and walked out the door.
All right. So you went in there, stole the power tools, or took the power tools, tried to walk out of the store without paying for them.
I did walk out the store.
All right. Store was open to the public at the time. You didn't have anybody's permission to take that property, did you?
Did not.
And this property you took, it was property that was offered for sale by Lowe's. In the other matter, on the day of October 25th, 2024, at the location of 700 Briarwood Circle, City of Ann Arbor, Washtenaw County, State of Michigan, what did you do at the Macy's that makes you think that you're guilty?
I tried to steal some merchandise that was not mine.
Okay, you went into the store,
Yes.
took some merchandise, tried to walk out of the store without paying for it.
Yes.
The store was open to the public at the time.
It was.
You didn't have anybody's permission to take that property, did you?
I did not.
And this was property that was offered for sale by Macy's?
Yes.
And these pleas to the second, are they based upon prior or value?
Value, Your Honor.
All right. So going back to the Lowe's transaction, was the amount of property that you walked out of the store with, was that greater than $200?
Yes.
And likewise with the situation regarding Macy's, your activities there, was the value of the property that you walked out with greater than $200?
It was.
All right. Sir, you understand that if I accept your pleas on these cases and you commit misconduct as defined by the Michigan court rule from the time I accept a plea to the time of your sentence, that you would not be entitled to any sense of value. The court would no longer be bound by any sense of valuation regarding this case, and you would not be entitled to withdraw your plea. You understand that?
I understand.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None that I'm aware of, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's pleas of guilty to these two charges: retail fraud in second degree, which is count 2 in each case. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A probation as well as 15th District Court probation. Sentencing in the case ending in 1463 will occur
October 8th.
October 8th, 2025, 9 a.m. That is before me. And that matter is bond will continue. In the other matter, sentencing will occur
October 21st at 9 a.m.
October 21st, 2025, 9 a.m. before Judge Val. Bond in that case will continue. All right. Thank you.
Thank you, Your Honor.
Court does call the case People versus Ashley Native.
Alexander on behalf of
Morning, Honor. Rough Chief Bill on behalf of Mr. Nader, who's approached Ashley, state your name.
Ashley Nader.
All right. I have before me a plea form that indicates that the defendant would be pleading to an added count to stalking the misdemeanor charge, a 1-year offense and up to a 5-year probation offense. And upon our successful plea to that charge, count 1 would be dismissed.
That's correct, John.
Ever sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth you got?
I do. Ashley.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of stalking. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs, and up to 5 years probation. You understand that?
Yeah.
You understand also that while I'm taking your plea, I would not be your sentencing judge in this case, and that you would be sentenced before Judge Rashad in the 14A4 district. Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yeah. Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. You said copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty. You'll be giving up those rights as well as all the rights on that form.
Okay.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
I don't know. It was here and it's not.
That's why I like.
Between the dates of July 1st, 2025 and July 8th, 2025, at the location of 7827 Sandy Beach Drive, Northfield Township, Washtenaw County, State of Michigan, what did you do regarding a Dustin Stroud that makes you think that you're guilty?
I was calling and texting when he didn't want me to.
Okay, you kept calling and texting. At some point during that process, approximately how many times did you try to make contact?
I have no idea.
More than 2.
Yeah. Few.
And had this individual told you not to contact them?
Yes.
And made that clear
Yes.
to you? And after that, you continued to contact that individual?
Yes.
All right. Ma'am, I have to indicate to you that between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to any evaluation. The court would no longer be bound by any evaluation or recommendation regarding your case, your sentencing in your case. You understand that, ma'am?
Yes.
And you would not be entitled to withdraw your plea.
Okay.
Counsel, have I complied?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your
Have I complied with the court rule? Would it be proper to accept this?
Yes. Gotta get there.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4. Probation sentencing in this matter will be
Don't worry about that.
October 28th, 2025, 9 a.m. before Judge Freshell.
Judge, yes, Judge, a couple issues.
Yes.
One being the tether. She's been on tether probably since mid-July. There have been no violations. I would ask, and quite frankly, Judge, I've told her, you've told her, if there's any attempt to call this young man, that she wrecks her deal with the court. I would just ask the court that no need for any the tether. Hold on. And the second issue, Judge, is the sober link. Now there's a report, and there's numerous quote unquote missed tests, but she works very odd hours. She has sleeping issues, which she's consulted with a doctor. To her credit, every time she's missed a test, she's always gone the very next day or within a couple hours. So there's absolutely no evidence of her drinking since July. We would ask the court if it would remove the sober link and the tether.
Well, the problem with the tether is she took off to Tennessee.
Judge, that was, she learned her lesson, Judge, on that. I would ask if you would please consider that. She's a hard working lady. It does interfere with her work. She's learned her lesson. She's not going to contact anybody.
Hold on. I have quarrels with that. Takes off to Tennessee. She comes back to court. We get after her taking off to Tennessee and everything else. And then she doesn't test properly on the SoberLink device. Now, it would seem to me that if somebody were that close to violating it, be remanded to jail until the conclusion of the case, and she kind of escapes that she would follow to a T the instructions of the court regarding her bond.
Judge,
she didn't do that to the extent
I can't listen to both of you.
that I had to send an order out directing her compliance again with the SoberLink, which we sent out on Thursday.
She said she never got the order. That's not the issue.
Oh, I can give you a copy. It was sent out on Thursday when we received it, but you've been missing tests all over.
Judge,
She's not been anything from the people.
I would object to the removal. Either Tether, as the court stated, she did make the state earlier. I do also concern that it was a sobering videos that came about or with the crown bottle. So I mean, I'm concerned that she can't follow her bond. So at this point, I would ask they remain as said, and it can be addressed as sentencing, but she needs to be compliant with the bond.
Judge, the only thing and I just want to reinforce this, and for what it's worth, any missed tests within an hour or two or shortly with another test was taken that showed no evidence of alcohol. I understand she missed her test, but to her credit, there was no evidence of alcohol.
I don't think she listens to really what the court is saying and just skates on the edge, quite frankly, Mr. Killowall.
Yeah.
I think the court very clearly told her she was not to leave the state of Michigan. And we have to, without the GPS tether, we wouldn't have known, but she's somewhere down in Tennessee. Then she gets back here. There's an admonishment regarding that. She's got instructions as to what she has to do, and she fails to follow it. She just continues to not blow when she's supposed to blow.
Okay.
And there are windows that she has to do it. It's not like she got to do it right at that point in time, and she just doesn't do it. I don't think she pays attention to what the court's telling her. And I think, quite frankly, I'm just going to dare you to do that before Judge Freshour, because I don't think she's going to tolerate any of this at all. Motion for bond reduction or any change in bond is denied. Bond is continued.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case People versus Brandon Fleming.
Aliens that we have.
Your name, sir? All right. We ready to proceed?
Yes, Your Honor. People are ready to proceed.
All right. You may call your first witness.
Thank you, Your Honor. People would call Lucinda Print up to the stand.
Ma'am, please come forward and be sworn.
Raise your right hand. You solemnly swear to testimony about you. So I was looking at the GG.
Yes.
She thanks for your personality and the record.
Lucinda Print up. E-R-I-N-T.
May inquire.
Thank you, Your Honor. Good afternoon, Lucinda. Lucinda, do you know a Brandon Fleming? How do you know him? Okay. And if you saw Brandon today, would you recognize him? And is he in the courtroom right now? Can you briefly identify something he's wearing and where he's sitting? And at the defense, is that where you pointed? Your Honor, please let the record reflect that this witness has made an in-court identification of the defendant.
That objection record so reflect.
Thank you, Your Honor. So, Lucinda, I'm going to direct your attention to August 4th of 2025. On that date, were you at a 2380 Carpenter Road? And is that in Ann Arbor, Michigan, County of Washtenaw? Okay. And on that date and at that location, did you come into contact with the police? Why did you come into contact with the police? And did you make that call? And after you first came into contact with the police, did you report anything that happened that day? What did you report to them? What happened?
I told them that prior to the thing that I had.
And who's him? And why did you have him removed? And did you report anything else happening during that argument? What did you report happening? And when you say he put his hands on you, how did he put his hands on you during that argument? He choked you. So when you say he choked you, how did he do it? With one hand, two hands? Okay. And did he put them around your neck? And could you breathe? And that argument that you're referring to, how did that argument start?
Started because
And after he accused you of cheating, how did it progress from there?
said because I previously took my phone charger, so I wasn't able to charge my phone. And I called a friend to bring me a charger, and they came to the store, bring me a charger, and
And that's when it became physical. Did he do anything else? And when you say someone contacted police, who was the one that contacted police?
well, the police told me that he was going to
And he is Brandon? And did anything else happen after that original argument? What happened?
if I wanted to get breakfast. And so we went down there to get breakfast, but I guess I was taking too long, so we came down there to get me. And on our way back, started arguing again. He started shooting, cheating. Walking to the door, he like nudged me with his knee, Bill, and drop off.
And when you say nudged you with his knee, what do you mean? How did he do that?
His knee.
Okay, where did he knee you? Okay. And Your Honor, can I have one moment?
You may.
Thank you. Nothing further for this one is from the people, Your Honor.
All right, very good. Cross-examination.
Listen, to my name's Bob Kilwald, and I represent Brandon. I'd like to ask you some follow-up questions. You said you were in a relationship with Brandon. How long were you in that relationship for?
For about 5 months.
Okay. Do you also have a child from him with a previous relationship? Okay, but is there another child also involved? No? So so you're pregnant and you believe it's his child? Okay. And on August 4th, you said you were at 2380 Carpenter Road. What is that? What's the name of the hotel? Okay. And were you staying there with Brandon at the time? So, okay. So when did you first go to the Days Inn? Okay. So you were there. It's my understanding you were waiting for housing. And so how long had Brandon staying with you at that time? I mean, did you move in together?
He just came.
Okay. He was invited in, correct? Okay. And, so there was an argument. You said there was an argument. Was the argument over the length of time it took for you to go and get a phone charger? What was the initial argument over? Okay, and all right. And do you know what the basis of, if you know the basis of him accusing you? Did you tell him something or do something? Okay. You made a police report, correct? And did you initially tell the police that he came into the bathroom while you were looking in the mirror and he shook you? Okay. And what happened during that incident?
He started yelling at me, saying, "Why you make me do this? Why you do this to me?"
And do you know what he was referencing? Okay. And you weren't cheating on him, correct? All right. And how did that incident end? This specific incident in the bathroom?
Now you have to go. Now you couldn't be there.
Okay. And what happened then?
And I started to grab his things, and I told him that either he had to leave or I was going to tell the people at the front desk to put him out.
Okay.
He grabbed me and put him arm around me and pushed me on the bed. Like my face was in the bed, and I kept trying to tell them my 10th grade. I kept telling them that I was lying.
So you just testified that he choked you. He never did choke you, correct? When did he choke you?
10th grade. Like he got off me and he put his arm around my neck.
Okay, so let me get this straight. So you say he bear hugged, is it a fair statement he bear hugged you and forced you on the bed face down? That's what you told the police? You then told them you can't breathe? How long were you face down on the bed? And were you telling him I can't breathe? And then how did you kick him or how did you get up? All right. And then it's your testimony today, then while you're still laying face down, he choked you? And how long did he choke you for? Did you tell that to the police that he choked you? If it's not mentioned in the police report, maybe you didn't tell the police that he choked you? Right. And at some point he let you up?
I hate him just in the bed on the floor.
Okay. And what happened then?
Take my hoodie off because I couldn't breathe.
Okay. And what happened after that?
Said, why you made me do this? Then he said he wanted me to go to jail.
At some point, did he leave? And you didn't have to kick him out, correct? He left on his own volition?
Have the people in the hotel remove him.
From the room?
Yeah.
Okay, so he leaves at some point, correct? Does he come back that day? So you allowed him back into the room that night?
Couldn't be in, so I had lost my visitors.
Okay, well, you also said in the police report, and correct me if I'm wrong, the next day you woke up and he was sleeping next to you in the hotel room. Is that not true? Okay, is this the day after the incident? I mean, the police report says that you woke up the next morning and he was sleeping next to you. Is that right or wrong? But you're saying it's not at day's end? Okay, let me back up. Because of this incident, you went to the hospital, correct? Okay. And I believe, I don't know if you went to Trinity Health, but subsequently after that, you went to U of M. Is that a fair statement? What hospital did you go to? Okay, let me back up. Weren't you taken to a hospital by an ambulance or? Okay. How long did you stay at St. Joe's? Did you describe to them your injuries? Okay. After that, did you contact him, my client? This was at a different motel? Okay. At subsequent to that, did you then meet him at his hotel room? Okay. And subsequent to that, did you then stay with him at his hotel room? Okay. What hotel is this now? We had the Days Inn. What's the new one? I'm sorry? Your motel? So you got a new room then after this incident? And then did you contact him? Did you invite him to your room?
I'm gonna check on relevance. I don't know where this is relevant to the.
What is the This is after the.
Correct.
But again, Judge, it shows her state of mind. I mean, if she was assaulted, as she's claiming by this gentleman, I would argue that she wouldn't be accepting a call from my client if that's what happened and then joining him.
If that were true, we'd never have a domestic violence case, would we? Yeah, I didn't think you'd have a response to that. Objection sustained.
What injuries did you incur? Okay, I know you're not a doctor, but I mean, did you have marks on your neck or anything to? Okay, now you say he smacked you. When you were choked, did you have any bruising on your neck? When you went to the hospital, did you tell the doctors you were choked? Did they find any injuries on you as to in the area of the neck where you would be choked? May I have a moment, Judge?
May. The microphone.
Oh, I'm sorry.
Sorry.
This may sound a little repetitive, but my clients, have you seen the police report? Have you ever reviewed it? Is there anywhere that you recall that says that he choked you? I just asked her if she saw it anywhere in the police report. I think that's a different question.
I mean, I'll overrule the objection. I'll allow her.
Have you reviewed the police report? Anywhere in the police report, do you recall seeing a statement made by you that he choked you?
That he had roughly around my neck.
In the police report? You told him he bear hugged you, correct? How did he bear hug you? Where were hands? Around your waist? Okay,
Mr. Fleming, one more outburst and you're out. Go ahead, Mr. Killow.
If I showed you your statement in the police report, could you pinpoint to me where you claim that you told the police that he choked you? To refresh your memory? May I approach, Judge?
Prosecutor, know which pages you're referring to.
Page 6 of 13, 6 and 7. May I approach?
You may.
This page in the phone. Did I get a chance to refresh your memory?
Yes.
Judge, may I approach?
You may.
I'm going to ask you one more time. Do you see any statement made by you in the police report that he choked you? Thank you. I have no further questions.
Can you read it?
Just briefly. Lucinda, at the time of this assault, were you pregnant? And you mentioned that you had injuries. Did someone take photographs of those injuries? Was it the police department? Your Honor, may I approach the witness people's proposed exhibits 1, 2, and 3?
Judge, I hate to make a technical argument. That should have been presented in the initial prosecutor's proof, Your Honor. And
Well, what are their photographs of injuries?
I see.
Correct?
Correct, Your Honor.
And maybe
Are they injuries around the neck area?
one picture.
Nope.
Which I would ask, I don't see an injury, but I'm sure you can testify.
Your Honor, it would be the pictures that she testified to on cross about the bruising on her face and the scratch as well as her hand.
For purpose of the exam, Judge, I still think the only appropriate picture, if the court's going to allow it, is the next picture. But
Well, she's testified to certain things that had occurred to her. You dispute them on cross. They should be able to come back to show their evidence.
that's fine, Judge.
So I'll overrule the objection. Go ahead. Yes.
Thank you. Lucinda, what did I just hand you? Who is in those photos? And are those photos fair and accurate representations of the injuries you received from the assault from Mr. Fleming? And can you describe, going through each one, on exhibit that's marked 1, what is that a picture of? And then picture 2, what is that a picture of? And then picture 3? Your Honor, at this point, I would move to admit people's proposed exhibits 1, 2, and 3.
Judge, I'm sorry, I didn't hear her answer on the third picture. What was it she said?
I think she said scratches.
Scratch on her face.
Scratches on her face? Okay.
Mr. Microphone. No, you go ahead. It's microphone. I just wanted to make sure that your conversations aren't being overheard.
Waiting for me.
I just moved for the admission of the people's exhibits 1.
Exhibits 1, 2, and 3 are ready.
Thank you, Your Honor. May we publish them to the court?
Yes.
My handful.
Hand me those. Thanks. Thank you.
Your Honor, 1 moment.
You win.
Thank you. Nothing quick.
That's very briefly. Yeah. For all your
Did at any time during this incident, did you hit my client multiple times in the face?
Yes, no.
Thank you.
You may step in.
No further witnesses.
Judge.
All right.
Well, at this point, I will move for bind over its charge. You heard from Ms. Printup about this incident that occurred on August 4th of this season on Carpenter Road. She testified to the defendant strangling her not only once with his hands, but also supported her face into the bed to the point where she couldn't breathe. She expressed that she couldn't breathe to the defendant multiple times and had to kick him to get him off. You also heard testimony that this stems from the defendant accusing her of cheating, and then that's where this argument arose from. On top of the 2 strangulation incidents, you also heard of the defendant slapping her. I believe we met the burden of probable cause and asked the court to find over the defendant as charged.
Phones.
Judge, just very briefly, Judge, if you look at those pictures, Judge, I would argue, again, neither one of us are doctors, but I would argue she admitted there were scratches on her neck. If somebody's going to choke somebody, there's going to be bruising on the neck, Your Honor. There's been no medical evidence presented that my client choked her. I would argue, Your Honor, that she made statements that he choked her. She could not find that in the police report, although she said she reviewed the police report and she told the police that. Judge, I don't think they've met their probable cause for as light as it is on count 1. I would argue that at most, Your Honor.
This Out of curiosity, how do you make you make that argument regarding the choking? But there was also testimony that her head is pushed down into the bed and that at that point she is not able to breathe, which would constitute, at least on the surface, suffocation.
Well, I would argue that when she said she couldn't breathe, he let her up, Judge. If that's what the court believes, he let her up. She obviously, I mean, I'm not trying to be facetious about that. She didn't die. He let her up when she said she couldn't breathe. But she also, Judge, her testimony's got to be suspect. When she said he then got on top of her and choked her after that. There's no evidence of that, Judge. You look at the pictures. There's no bruising on her neck. And the fact that there's nothing in their police that she ever told the police that he choked her. So I would argue again, Judge, that at most, Your Honor, the court should only bind over on count 2. Thank you.
Anything else from the people?
I would just put on the record that in many instances of strangulation, injury is not normally present or able to be photographed. So I think that the fact that there's no injury not only doesn't negate testimony, but it also isn't an element of crime.
Being probable cause hearing, the court would find that the people have indeed sustained their burden as to both counts 1 and 2. I think with the record, you know what, Mr. Fleming?
Judge,
you got one more time. Am I understood? I am not man. Take him out. Do not ever refer to me that way. Gilwald, I'm going to give you a minute. I know you're supposed to be downtown, but I'm going to give you a moment to go around there and check your client before I bring him back out. Because otherwise we're going to have a problem. And Mr. Doc, next time you tell me something is going to be quick, I will know not to believe you. I knew not to believe you because you were an attorney speaking to me and telling the court that, but I tried. I was late. Thank you. All right.
He's.
Did he? He did say that.
Yeah, he said that.
It'll be out. Yeah, see if we can roll that up.
Okay.
Because who's on the other side of that?
May I just sign the information?
Why is he's so bossy? Go. I'm sitting there having a conversation with my judicial staff. He is just slowly creeping up. Just creeping toward the back. In fact, we almost had to take him down. Yeah, that's what I'm talking about. And then says, can I sign the information like he's got business?
I would like to say, ask May. I understand we're going to always say no on our worst decision.
When you're halfway up here, yeah. All right, we're going to try. Counsel, I will do this case if we're going to have 5-10 minutes. I got a living headache, and then I will get everybody out. What's wrong? It's you.
No. We're not denying that. I'll be here tomorrow.
Wow, just threats.
Good.
Court stands in brief reasons. All rise.
Judge, my apologies. Judge, can you hear me?
Yes, we can hear you, Bob. It's
I
okay.
really do apologize. I think, never mind. I think I fell asleep, but no, just kidding. It is my client also on Zoom?
He's been on Zoom. Yes, now he is. Thank you. All right. Court does recall the case of the people of the state of Michigan versus Brandon Fleming.
Ailey Zend on behalf of the people.
Good afternoon, Your Honor. Robert J. Kill on behalf of Mr. Fleming. Brandon, would you state your name for the record, please?
Hello?
Yeah, state your name.
Brandon Fleming.
All right. We were at the point in the preliminary examination and I was giving my decision on bind over. In this case, the court would find that the people have indeed sustained their burden. The case, while certainly the defense may make some arguments regarding the these photos of particular injuries, the court having heard the testimony of Ms. Printup, the court, well, that testimony, any dispute regarding what she is saying, what's in the police report, that the court would find constitute factual circumstances, which which rightfully should go before a fact finder and should not be the subject matter of these proceedings. I would also indicate, because I believe that I was at the point of the issue regarding suffocation, the suffocation and/or strangulation. She testified actually to two events, which would, I believe, be recognized under the statute. That's the suffocation in the bed and the hands around the neck. I will not add an additional charge of that, although this court does believe, given the circumstances, that the court could do that. But just leave it at the one charge. And so, court having found that, the court will bind the defendant over to stand trial on both counts.
Judge,
Mr. Kill, go ahead.
If we acknowledge receive the information, waive its reading, my client would stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for October 30th, 2025, 1:30 before Judge Slay.
Judge, may I address bond?
You may.
Judge, I believe, if I'm not mistaken, he's under a $25,000, 10%. Is that accurate, Judge?
Let me see. I have 20,000 cash.
Okay. Would the court, Judge, I know this isn't, it goes to the credibility of the victim. I think there were moments shown that well, I'll just leave it at that. I believe that her credibility is suspect. That being said, I'm asking the court if it would release my client on a tether or give a nominal bond of 2,500, 10%. My client promises not to have any contact whatsoever, even though she's claiming it's his baby. My client is gainfully employed, and that he could be residing at his aunt's house. And Miss Langford, I don't have the address with me, but he can be gainfully employed, reside with his aunt, have a tether, and he's not a threat to the public, Judge. So for those reasons, I would ask you to please consider a bond. I know the court's made its decision regarding the bind over, but I think some statements are suspect. And based on that, Judge, I would ask the court to give some leniency to allowing my client to be released from jail.
Response.
Your Honor, in this case, we originally requested $50,000 cash surety. At this point, I would be renewing that request given the testimony heard today. Ms. Printup, the court heard her testify to two different incidents that would fit under the strangulation statute, as well as a DV incident that was separate from those incidents when he kneed her in the back. All this occurring while she was pregnant with their child. I mean, I have concerns given his history as well. He has a previous conviction from 2015 for 2 domestic violence counts, as well as an assault with intent to commit sexual penetration account that was DV related. So between that and the testimony the court heard today, I have concerns that he is a danger to the community and a danger to Ms. Printup. Also, given the fact that in this case, I just have general concerns given the facts of this case and the fact that after he does assault her, he then tries to call 911 and pretend to be her. by saying that she's suicidal and has a knife. I mean, I have concerns that
Judge,
even if
that
he's
was,
not
Judge,
contacting.
I don't mean. I'm
Mr.
sorry, I don't mean to
Kilowog.
interrupt you, ma'am, but that was not, there was no testimony. I'm sorry.
And Ms. Printup did testify to that he called 911 and it wasn't her, saying that she was suicidal. She did say that on the stand today. So I have concerns that he would try to do things like that indirectly. While he might not be contacting her directly, he would be trying to do things like that. So at this point, I would be re-requesting our original ask of $50,000 cash surety with no 10%.
With reference to bond in this case, I have some concerns. While certainly there's dispute regarding the testimony in the case, I will not raise the defendant's bond, but I'm not going to lower it either. I would consider, quite frankly, Mr. Kilowog, the ability to lower his bond or think about another way to release the defendant. However, frankly, his behavior in court caused his own demise in that regard. He just couldn't control himself. I gave him the warning and tried to just tell him to not interrupt the proceedings, and he just couldn't do it. And I don't have great confidence that he would follow this court's orders. So the motion for bond reduction is denied. Maybe Judge Slay will feel differently once the case is in front of her, but I do not feel that way. So bond will continue.
Thank you, Your Honor.
Judge, I know you've made your decision, but I think in fairness to my client, it was out of exasperation, what was being said about him, but I'll respect the court's decision. Thank you.
And that happens with every defendant before us whenever we're hearing it. Some are able to control themselves, some are. Your client is in that category where he could not control himself. So, thank you.
All right. Thank you, Your Honor. Take care. Take care. Allie, I'll be contacting you.
Sounds good, Bob.
Thanks.
14. Dan.
All right, this is case 25-0075, Taylor versus Mariah Curry. And this is the date scheduled for pretrial conference.
Morning, Your Honor. James Kazicki on behalf of Ms. Curry. Ms. Curry is going to enter a plea to the reduced charge of disturbing the peace, the requirement of taking a anger management class. There's no restitution. And that's it.
All right. Hi, your name, ma'am?
Naraya Curry.
All right. Do you understand the plea agreement?
Yes, I do.
Is that the agreement you'd like the court to accept?
Yes.
All right. And we have the victim here too. Is that Kara Johnson? Hi. You're muted.
No, Judge Jeffrey Day.
Who's the victim?
Jeffrey Day.
Oh, okay. I've got the wrong person. So Jeffrey Day, is he there? Oh, you're Jeffrey Day.
He's just muted.
And you're the victim?
Yes, sir. Can you hear me now?
I can, Mr. Day.
Right.
Yes. All right. So, yeah, well, I'm going to take the plea, then I'll ask you for your comments and statements and complete your opinion on this. So, yeah. So, does anyone force you into this plea agreement to plead to the amended charge disturbing the peace and dismiss the assault and battery, Ms. Curry?
No.
And is this your own decision then?
Yes, I would, but I was told something completely different before this court date. But I don't want to take it to trial, and I'm trying to keep the assault off of my name, considering that I do have a 5-year-old and I'm in school for nursing.
All right. So, you agree to this plea agreement?
Yes.
And, yeah, has anyone forced you into it or promised anything different?
Yes, I was told something different my last court date.
All right. How about today, though? You understand the plea agreement for today?
Yes.
Is there an agreement you want to accept or no?
I just want to make sure that there won't be an assault charge on my name because I am in school and I'm not trying to affect anything that's going to affect my life or my child's.
So the assault and battery charge is to be dismissed if you plead guilty to disturbing the peace is the plea agreement.
Okay.
All right, so yeah, you'll be subject to fines of up to $500, 90 days of jail plus court costs. And it doesn't appear there's restitution, but we'll find out about that in a moment. You understand?
So I'm paying 500 or 90 days.
No, let me rephrase that. These are the maximum penalties. $500 of fines, 90 days of jail plus court costs are the maximum penalties.
Okay.
You give up rights when you plead guilty, you're giving up your right to have a trial by judge or jury. Do you understand that, right?
Yes.
And do you give up that right?
Yes.
And you'll give up all the rights listed on the advice of rights form I'm showing you. Did you have an opportunity to read one of these or have it read to you?
Yes.
Did you understand those rights?
Yes.
And do you give up those rights?
Yes.
How do you plead to the added charge of disturbing the peace?
Guilty.
All right, Mr. Kazicki, do you want to voir dire question for a factual basis, Ms. Curry?
I don't have the dates and times in front of me right now.
All right.
I turned the file into the court.
All right, well, I'll proceed then. On November 5th, 2024, were you in the city of Taylor?
Yes.
All right, did you get into some sort of, where were you located specifically?
I was at the Wendy's on Ecorth and Monroe Street.
The Wendy's on Ecorth, and that's in the city of Taylor?
Yes.
Were you a customer or were you working there?
I was working there. I was the general manager at that time, and the defendant came into the store. He was irate.
You are the defendant.
I mean, I'm sorry, the victim.
The victim.
Can you hear me, Your Honor?
He came into the store.
Here, let me just go back a little bit. You're pleading guilty to disturbing the peace. You understand?
Yes.
Did you? All right. So you're at the Whitney store in the city of Taylor on
November 5th.
On November 5th, 2024, and you're the general manager.
Yes.
And did you somehow disturb the peace while you were at that Wendy's store in the city of Taylor on November 5th, or did you commit an assault and battery?
In my opinion, I didn't disturb the peace because the victim came in, and yelled, and I tried.
Can I stop you a moment? Let me just stop you just for a moment. I'm not telling you you were disturbing the peace or committed an assault and battery, and you don't have to plead guilty to either of those things. But my job, and one of the things I have to make sure of, is that if someone is pleading guilty to a crime, that they're telling me that they committed a crime. If you do not feel as if you committed an assault and battery or you committed disturbing the peace, you shouldn't be pleading guilty. But you cannot have it. And I just stopped you. I'm not trying to argue with you. I'm trying to explain. You cannot have it both ways. You cannot plead guilty to disturbing the peace and say you're not guilty of it. I won't do that, and I can't do that by law.
Yes, I
So
understand.
you have to make a decision here. Either you're pleading guilty and you have to explain to me how somehow you may have committed a disturbance of peace or an assault, or continue, or let me just finish without interruption, or continue to a trial. It's up to you. I'm not telling you what to do. I'm not trying to argue with you. I'm not trying to tell you to plead guilty to disturbing the peace. I'm only explaining to you that if you intend to plead guilty to disturbing the peace, you have to tell me words and acts that would support that you were disturbing the peace. Do you follow what I'm saying?
Yes, I
And that's it both ways. You can't say, I didn't do anything wrong, I didn't disturb the peace, but still I want to plead guilty. That's not something I can do, and the law won't allow me to do it.
Okay.
So go. Did you want to continue with the plea? And
Yes, I
tell me
want to
that-
continue with the plea.
All right. Well, tell me how you disturbed the peace that day.
I asked him for the food back. He tossed it into my face, and after that
Your Honor,
situation,
there's a video for this.
Carol, there's video.
I'm the prosecutor. I apologize for interrupting. I just came in. There's a video of this.
Watch it.
And I know Mr. Day's version of events and that I've seen on video. That he did not throw anything in her face, and I'm not going to allow this.
Yeah, and thank you, sir.
That's all right, Mr. Day.
All right, here's the deal, Miss Curry. This isn't a trial. This is a plea. I'm not trying to tell you what to do or what to say, but there's clearly disputed facts here. I'm not going to accept the plea. We'll just continue it. We'll set it for a trial date. I think maybe that's the best way to go under the circumstances. You're entitled to a trial by judge or a trial by jury. It's your decision, but you can't plead guilty and tell me that you did nothing wrong or it was the other person's fault. Maybe it was, maybe it wasn't. I don't know. You're presumed innocent unless you're proven guilty beyond a reasonable doubt, and you're entitled to a trial either by judge or jury.
I'm sorry, I just didn't know how to explain it to you. That's all.
No, that's fine. You don't have to apologize, but I can't accept the plea if you didn't disturb the peace. Yeah, it's that simple. And no one's trying to pressure you into anything. I'm just trying to, I need to follow the law. And if you didn't do anything wrong, then I'm not going to accept the plea.
Well, yes, I did do something wrong by I just don't know how to explain it to you. I really don't know how to explain to you.
All right, well, let me ask some other questions. And no one seems to be, I don't know what happened. I haven't seen any videos. I haven't read the police report. I really don't know what happened. And I'm not, Mr. Day, I know you want to speak, but you're not involved in this. You will be shortly. You're the victim, but I don't want a trial going on or a mini trial.
Well, neither do I. I think that she should have, if she was smart, she would admit responsibility.
All right. Well,
I don't want anything I don't want her to, to be in trouble or anything like that. And it would be easiest for her to do it, because if you did watch the video, you would probably agree that she should.
Oh, okay, but I haven't, and we're not at a point, so.
I don't want to.
All right.
And I do say I was wrong for what I did, and I do want to say
what was wrong about what you did? What did you do? I mean, did
me going outside.
Throw something? Did you punch or do something to Mr. Day that would have been considered unlawful?
Yes, I repeatedly punched Mr. Day when I went outside. So yes, I am wrong for that, and that's why I will plead guilty to disturbing the peace.
All right. Are you satisfied, Mr. Kasicki? You've been awful quiet during this process.
Sure.
Yes.
Yes.
I'm satisfied as well, Your Honor. All right. Well, so I accept the guilty plea then, based on that statement to disturbing the peace. And did you want a pre-sentence investigation, Mr. Greco, Mr. Kasicki, or do you want me to try to go ahead with sentence under today?
I think we recommended 771.1 for a period of time, Your Honor, and I'm good with that. But I think
no, that's not. I don't see that written down. Is that something that you
have? 771.1.
Oh, that was
we'll take it. We'll take it.
Yeah.
That wasn't. That's not on the plea agreement form.
We'll take it, Your Honor.
Yeah. No, it's 771.1 I have on my sheet, Jim, I think. And
okay, on our communication, I didn't see that, but we'll more than happily take that.
What is that?
And I'll explain that to you after we're done. What it does is, after a year, automatically off your record.
Okay.
And Your Honor, I believe that. Yeah, and just one more. I apologize, Your Honor, but as part of the plea, I think she meets one time with the probation department, and we're recommending an evaluation for anger management.
Okay.
Up to probation.
So what are you saying? Sentence now, refer to probation and consider for an evaluation for anger management?
Yeah. To 771.1, 12 months. I think Jim, right? They meet with probation the first time. I think, is there an initial meeting with probation?
Right. We had, in our discussion, I thought it was a anger management class, not the whole management thing.
Yes.
Yeah. Okay. Yeah, she has to meet one time with probation, yes.
I don't agree to that.
All right. All right.
I
So,
come in
yeah,
and
I
get the files.
accept the- Pardon?
Guys, right there.
All right. So, yeah, Mr. Day, all right. Can take your statement at this time, Mr. Day. If you'd like to,
Sure.
Are you asking for any restitution or anything, money damage?
Yeah, how are you, Your Honor? I'm the victim in this case. I don't even know where to begin. First of all, what is 77.1?
So that's a delayed sentence where basically it's you're placed on probation and some sort of supervision for a period of time. And if there's compliance with that probation and the terms of the sentence, then the case is generally dismissed after the completion of that probationary period.
Okay, gotcha. Okay, so I want to explain how serious this assault was for me. Before and during the attack, the defendant directed hateful slurs at me, which made the assault not only physical but also very degrading and traumatic. As a result of the incident, I have ongoing medical issues. I had to see an eye doctor. I even had to have a CAT scan done because now I see white lights out of the corner of my left eye. I suffer from headaches. My phone was broken during the assault. I understand that she does not want a felony on her record, but what matters to me is that she takes those responsibilities and get the help that she clearly needs. If she truly wants to go into professional like nursing, she needs to demonstrate self-control and respect for others. I think angry management, more than one day class should be the case. One class is not gonna help. It's not gonna do anything for her. Yeah, that's all I got to say. And I'm not asking for her to pay for any of my doctor's stuff. I just want her a new phone. I just bought the phone the day before she broke it. And
you just want her to do what?
I just want her to pay for the repair of my phone, the screen, the repair of that. I don't want.
Mr. Day, I told the defense attorney you said you didn't want that.
I told you no. I said I did not want her to pay for my phone. I told you I did not want her to pay for my CT scan, which is in the thousands. I did not want her to pay for my eye doctor. I did not want her to pay for the specialist that I'm going to have to go to. Only thing I wanted was her to pay the $100 for the screen. That's what I agreed to.
You never said that to me. I apologize, but it's okay.
I have a recording.
Mr. Day, it's okay. It's okay.
If you'd like to see it, I can rewind and show it to you if you'd like. I can send it to the judge. That's what I agreed.
Fine. It's fine.
Because I do have the recording. I mean, she feels that she's done nothing wrong, which is crazy. I didn't throw anything at her. If you watch the video, I handed her the food and she decided that she was gonna, as soon as I handed her the food, she grabbed the pop and it spilled all over us and she decided that she was gonna punch me in the head like 3 or 4 times inside and then a couple times outside. And then I had another employee try to jump me while the manager sat there and watched. And I think more than one class of angry management would be fair. Considering that I don't want her to pay $5,000, if not more, for all my medical bills. I'm not asking for that. I just want my phone fixed because that's the only thing that I'm really concerned about. Well, I'm concerned about the light in my left eye and my headaches, but I just want my phone fixed. And that's like $100 or something like that. If that, I don't know how much it costs to fix a screen anymore.
All right. So did you? So
you can pay that over time. She can give me $5 a month. That's fine, as long as she pays for my phone.
All right.
She can give me $1 a month. It's not about that. It's about.
All right. I hear you, Mr. Day, but let me just verify, Mr. Gazicki, Miss Curry. I don't know if that's because the agreement was no restitution. Now it's $100. So
She can give me a $4 a month. I don't care as long as she.
all right. Thanks, Mr. Day. Let me just try to identify whether or not that can be part of the agreement or not. Thank you.
John, I'd have to speak to Ms. Curry on this. And Mr. Can we?
All right, so you can go into a breakout room.
Even a penny a month. I don't
Pardon?
care. I even a penny a month. I don't care as long as she gives me something.
All right, thank you.
It can take her 30 years to pay for it. I don't care.
We're going to place him in a breakout room, Mr. Day, and determine if that's going to work out or not.
Sorry to be difficult, but.
All right, so this is recalling Mariah Curry, case number 25-0075. So, Mr. Gazicki.
James Gazicki on behalf of Ms. Curry. We've had discussions. She's agreed to the $100 restitution. All she's requesting is a payment plan because she is a student right now. And she does have children that she's supporting.
All right. Well, thank you. So do you understand that revised agreement, Miss Curry?
Yes.
All right. And is that acceptable to you?
Yes.
All right, Mr. Day, do you understand that revised agreement that you'd be pleading guilty to disturbing the peace under 771.1 for a period of time and refer to probation for anger management as directed, allow payment of $50 a month? Well,
She can do less than that. She's a mother. I don't care. I told you she can give me a penny a month. I don't. It's just I want her to pay for it. So.
All right. So she'd be paying restitution of $100 to you. Is that all acceptable to you as a Mr.
I agree.
Day?
Yes.
Is there anything else you want to add this time?
No, I'm good.
Okay. All right. So
I think she owes me an apology, though. Besides that, but
Mr. Gazicki, anything else you want to add?
No, Your Honor.
Miss Curry, before sentencing, anything else you'd like to say?
No, Your Honor.
So yeah, I have accepted the guilty plea. Finding it's been made knowingly, voluntarily, understandingly, and accurately under 771.1. And so you're going to be on probation, Miss Curry, then for a period of 6 months.
I thought it was a year.
During that time, you're not to violate laws or ordinances, come to court into probation when required, advise the court of changes of address or telephone number, no contact, direct or indirect, with Mr. Day. No referencing him on Facebook or any other social media.
Okay.
Fines and costs of $350 plus a $100 restitution to Jeffrey Day.
Your Honor, I didn't know that you're going to suck her with $350 in court fees. Forget my $100.
You want to waive the $100, Miss?
Yeah, she's a mother and she's trying to go to school, which I doubt she is, but she is a mother, and I don't want to forget the $100 if you're going to suck her with $350 in court fees. But I want an apology.
Well, I can't guarantee that.
Well, then I can't. Then I won't waive the $100. So is either an apology is worth $100 to her or not?
I paid the $100, Your Honor.
Right. All right.
Well, if she wants to be like that, I cannot agree to anything.
You know, Mr. Day.
No, that's craziness. Craziness. If she can't even apologize when I'm trying to help her out because she's a mother and she can't even apologize, she'd rather take the $100. Forget that. Sock it to her. I wanted to go to trial. Let's do it that way. Let them see the recording of what she did. She assaulted me. I didn't attack her. I didn't throw anything at her. She's an angry woman. And no, I don't agree to anything if that's the way she wants to be. If she doesn't want to apologize, a simple apology, no. Then she wants to be shit. No. Apology or I don't agree to anything. I don't agree to 7.1. First of all, he didn't say 6 months, he said a year. Now it's 6 months from the start since I've been on here since 8:30 in the morning.
You've been what?
Everything that they say one thing and they do another. It's the craziest thing. And she can't apologize like I feel I deserve. And I'm trying to be nice enough to get because she's a mother and waive the $100 because you guys are socking $350 to her and she can't even apologize. She says, I'd rather pay the $100. No, then I'd rather her get assault and battery if that's the way she wants to be. So it's assault and battery or nothing.
Your Honor, if I may interject, I know the state law allows the victim to have an input, but the court is not bound by that. We have an agreement with the prosecutor's office. We're asking.
Yeah, we had an agreement before she got. No. I don't
agree to Mr.
I have recording. I don't agree to anything.
Mr. Day, I'm going to let you speak to the prosecutor. Ultimately, it's up to the prosecutor. Can I just finish with trial? Let me just finish without interruption, Mr. Day. Because only one person, you can only record one voice at a time. So I'm going to have you talk to Mr. Greco. Mr. Greco has the ultimate decision on how he wants to proceed with the case. And
I will make
tell
with the court.
Tell Mr. I'll put you and Mr. Greco in a breakout room, and you can express to Mr. Greco your concerns and whether or not you are agreeing or objecting to whatever the proposal is.
Difficult for you, but all I asked for was an apology. If she can't give me that, then
no, you're getting a plea, Mr. Day. And she's fled, Your Honor.
I don't agree to it. She can. I say that since you guys are. Did you hear the whole thing? All I want was an apology. I will drop the $100 for my phone, and because you guys are giving her $350 in fine, I decided I would be a nice guy about it. She can't apologize. She says, "No, I'd rather pay the $100." She's obviously angry, and she needs. I don't agree to nothing. I want it to go to court by jury. So either apologize and go against what I'm requesting. Then
Your Honor, has there already been a plea?
We'll take this to court.
No, I haven't
I will sue her.
Plea yet. No, there's not an acceptable plea at this point. There's just too much confusion. And
I'm not confused. Let's be clear.
I'm not accusing you. I'm just saying in general, Mr. Day.
Jim, do you want to meet me in a room?
Honor, as I indicated, the prosecutor made a valid offer.
I'm done.
We've accepted the offer.
I'm done.
The victim could be quiet so I can address the court. Your Honor, an offer was made to the defendant. We accepted the terms of the offer that was conveyed to us. Then Mr. Day is going to start injecting other conditions. I don't think that's appropriate. The prosecutor made an offer. We accepted. And I think we should proceed as it was agreed to.
Well, but here's the thing, Mr. Gazicki, Mr. Greco, Curry, Mr. Day. The victim has a right to make a claim for restitution. He has claimed a lot more in various ways, somewhat vague, of eye injuries and MRIs and additional out-of-pocket costs. And he's entitled to pursue that. And that's a consideration. And the court would have to consider that if, as far as conduct a restitution hearing, require him to bring in evidence of all these costs. Then the court would have to consider, that's part of the sentence. And so it's kind of hard to accept this plea with the prosecutor just, indicating the amount of restitution. I think the court has a duty to.
If I agree to
Your
apologize.
Honor, Ms. Curry, please. Your Honor, if I can address the court. All right. As I indicated, the defendant was willing to accept the offer as made. I think it's totally wrong for after we agree to accept an offer that someone's the complainant in this case is going to come forward and put, since you accepted that, I want more conditions. That's inappropriate, Your Honor. We accepted the offer, the $100 restitution, the 771, the disturbing the peace, and I think the prosecution is really bound by that right now.
All right, but it's become complicated, and I think its restitution claims need to be given a hearing and an opportunity for a court to consider them before.
Your Honor, he already agreed to $100.
I mean, but there's changes, and I hear what you're saying, Mr. Gazicki. Certainly, this case has gone back and forth on this issue a number of times, but ultimately, if the victim is agreeing to a certain amount of restitution, it's fine. But if the victim, changes his mind and says, before the court
I
accepts.
to apologize if I can just have this over with.
Yeah. Mr. Day, are you okay if Ms. Curry apologizes? Will you waive the $100?
Yes, if Ms. Curry wishes to do so, fine.
Do you want to apologize, Ms. Curry?
I just want this over with.
If you apologize, it looks like Mr. Day will give up any claim for restitution.
I do. I apologize for everything that happened, but I just want this over with.
Is that acceptable for Mr. Day?
I think she apologized, Your Honor.
Okay, are you satisfied at this point, or where do we stand now with your position, Mr. Day?
You're on mute, Mr. Day. Are you?
No, I'm yes. Thank you for the apology. I'm good.
Okay.
What does that mean? What does that specifically mean? That you're waiving the $100?
Yes, I will waive the $100. I won't take her to court. Everything. I'm all good. I'm satisfied with.
Very good. The prosecution's satisfied, Your Honor.
All right. So you're satisfied, Mr. Gazicki?
We're satisfied, Your Honor.
All right. So I will continue with accepting of the plea to disturbing the peace under 771.1, 6 months of probation. As indicated, no contact with Jeffrey Day, $350 fines and costs, assessment through probation regarding anger management. And anything else, Mr. Griffin?
No, Your Honor.
No restitution. All right. So you need to meet with probation. We're gonna do $50 a month. Starting. When can you start making those payments, Miss Curry?
I
I do October, Your Honor.
October 1st.
All right. So you need to meet with probation and let's set up an appointment with the Taylor District Court Probation Department. And then a review hearing in 6 months. Do you do review hearings here, Mr. Kirko, to determine this?
No, it gets scheduled for review administratively. And if there is no, further indications of any issues with Ms. Curry, I believe the matter just gets ultimately resolved at that time without
All
her
right.
further appearance.
All right, you definitely need to meet with probation, Ms. Curry, so contact the probation department.
Okay.
All right. All right, anything else then, Mr. Gazicki, Mr. Greco, Mr. Day?
No,
Well,
sir.
Thank you for listening to my what I.
All of you.
Thank you.
We're good.
You're good, Mr. Day.
Have a great day, guys.